हमेशा आई थी सामने सुबह मेंशन करना था, बट इसमें आपने बाद में सिंपल डिसमिस बोल दिया था कि वो अफेक्ट करेगा केस को जो आपने रिपोर्ट किया था, तो उसके बाद प्लेन डिसमिस बोला। उसमें लिखा हुआ है सिंपल डिसमिस।
What they say, we have not done it.
Other side was also there. Other side was also there. Not was urgent. 2 weeks. You have to kindly give me 2 minutes. You have to kindly.
No.
It was only urgent. Kindly see, we were there. The other side, the government council was also there.
No,
he said 2 weeks.
He's right. We have dismissed it. We have dismissed it.
But
You wanted adjournment, but we dismissed it.
no, you also granted 2 weeks. You also said, no, we heard it. 5 years sentence, you have to kindly consider this.
But then you simple dismiss.
ये फाइल के साथ रखना मेरे पूरे फैक्ट याद नहीं आ रहे
जी।
Let me check it with the file. I will recollect the facts then.
Very great.
चलिए वो रिकॉर्ड है वो सेल्फी का रिकॉर्ड है उसके साथ मुझे चेंबर में रखा दूँ
मैं बोलूं
Yes, Mr. Simple.
When I got up, your lordships got up. Sorry. Let us speak. Got up with the proposition, Muller,
Yes.
that once an offence has been committed, there is no subsisting fundamental right, even if a fundamental right is valid. Right? All these offences that they are alleging have been committed according to them, that's their allegation. But then how do they move on this under Article 32? Because the offence is already committed. That's the one that's the proposition I mentioned. Then, Malad, I want to just cite another judgment before your lordship, which is Northern Corporation versus Union of India. Because this is a case under the Customs Act. The petitioner in the petition contended that he has a fundamental right because the duty was not liable to be paid, and he has a right under 19(1)(g). The court made certain observations which may be helpful, Mullah. As far as I am concerned, Mullah, kindly come to paragraph 11. Again, a 32 petition was filed by him. Page 244, Mullah, paragraph. The issue related to payment of duty, Mullah. And he said it was not payable. Because it was not payable, his fundamental right was impacted.
Yes.
In para 11, this is what it says. However, there is a far more serious objection in entertaining this application under 32. That's at page 244. Article 32 of the Constitution guarantees the right to move Supreme Court for enforcement of fundamental rights. If there's a breach of the fundamental rights, the petitioner can certainly have recourse to 32, provided other conditions are satisfied. But we must, in all such cases, be circumventive of what is the right claim. In this case, the petitioner as such has no fundamental right to clear the goods imported except in due process of law. Now, in the facts of this case, such clearance can only be made on payment of duty as enjoined by the Customs Act. In a particular situation where the customs duty is payable at the rate prevalent on a particular date or not, has to be determined within the four corners of the Act. Petitioner has no fundamental right as such to clear any goods imported without payment of duty in accordance with law. There is a procedure provided by law for determination of payment of duty. The revenue has proceeded on that basis. The petitioner contends that duty at a particular rate prevalent at a particular date was not payable. Petitioner cannot seek to remove the goods without payment at that date or without having the matter determined by the procedures envisaged and enjoined by the law for that determination. Petitioner, without seeking to take any relief within the procedure envisaged under the Act, had moved this court for breach of fundamental rights. This is not permissible and should never be entertained. In a matter of this nature, where liability of a citizen to pay a particular duty depends on interpretation of law and determination of facts, and the provision of a particular statute for which elaborate procedure is prescribed, it cannot conceivably be contended that enforcement of those provisions of the Act would breach fundamental right, which entitle a citizen to seek recourse to 32. We're therefore clearly of the opinion that relief under 32 is wholly inappropriate in the facts and circumstances of the case. It is further to be reiterated that enforcement of a fundamental right, which is dependent on adjudication or determination of questions of law as well as questions of fact. Just pause here. Enforcement of a fundamental right, which is dependent upon adjudication of determination of questions of law as well as questions of fact, without taking recourse to the provisions of the Act, it is not permissible to move this court on the theoretical basis that there is a breach of fundamental. You make an allegation, then you say there's a breach of fundamental right, and then you say, grant me the relief, Mullahs. The court says you can't do that. Because I'm not going into facts, Mullahs, at the moment we're only on this initial proposition, Mullahs, that this petition doesn't lie. But there are issues of fact which, Mullahs, we have contended in our counter, which we're not going into now. But the law is quite clear that where is a determination of law or fact is yet to be made, they can't move under 32. Whenever a person complains and claims that there is a violation of law, this is another important thing. It does not automatically involve breach of a fundamental right. So they say there's a violation of law, Mullah, because I was not allowed to discharge my duties. That per se will not lead to breach of a fundamental right. It does not automatically involve breach of a fundamental right for the enforcement of which 232 of the petition is attracted. It appears that the facts of this nature require elaborate procedural investigations, and this court should not be moved and should not entertain all these averments of Article 32. This position is clearly well settled, but sometimes you are persuaded to accept that an allegation of breach of law is an action and breach of fundamental right. This is what I was trying to, Mullahs, canvass before your lordships. Your lordships should not and must not assume that an allegation is a fact and then on that basis entertain a petition under 32 without the investigation of both the fact and the law. So, Mullahs, again, this is directly on point, Mullahs, on that particular issue.
Yes.
So, I'm almost done, Mullahs. I won't take much of your lordship's time. Just want to make sure that I have placed everything. So I've already said no. Straight, this all will be done. Present is conceived, 36 done. Everything is done. Now, Mullahs. Now I'll encapsulate, Mullahs, in 5 propositions what my propositions are. Proposition number 1. In the absence of a continuing violation of a fundamental right, a petition under Article 32 will not lie for breach of that right. That's point number 1. Point number 2, that officials of the government acting under a statutory provision, under a law, in the event of obstruction in the performance of their duties, their fundamental rights cannot be invoked, since such statutory authorities, in exercise of their obligations under the statute, have no fundamental right under the law. They have no fundamental right. They're only a statutory right.
Yes.
Point number 3, in any event, as far as this petition is concerned, Mullahs, neither the Enforcement Directorate, which is not a department of the Government of India or a statutory authority, cannot move under Article 32, which is the relief claimed by the Enforcement Directorate. Next, Mullahs. The individual, namely Robin Bansal, fundamental right has not been breached, nor has it been claimed in the petition that it has been breached. Therefore, Robin Bansal, in its capacity as an officer of the Enforcement Directorate, cannot move this petition. That's number 4. And the last point, Mullahs, is a Mullahs proposition that they have, Mullahs, addressed in the petition, that they are acting as parents patria. Mullahs, parents patria jurisdiction is available only when those aggrieved have no capacity to move the court, as settled in, I'll give your lordship the judgment, Aruna Ramchandra Shanbag, (2011) 4 Supreme Court cases 454.
Page
454. In this paper book, Mullahs, it's at 746. No, it's not. We'll just give it then. Give it. Not give it, not maybe. Where or not?
You only refer to paragraph. We have noted it, 2011, volume 4, SCC 454.
Anyway, Mullahs, paragraph 126. I'll just read it, Mullahs, your lordship permit me.
Yes.
The doctrine of parents patria, father of the country, had originated in British law as early as the 13th century. It implied that the king is the father of the country and is under obligation to look after the interests of those who are unable to look after themselves. Unable to look after themselves. The idea behind parents patria is that if a citizen is in need of someone who can act as a parent, who can make decisions and take some other action, sometimes the state is best qualified to take on this role. The Constitution,
Maybe downtrodden, marginalized.
That's right.
And ED is not downtrodden according to you. They are all.
No, Mullahs, I thought that we were downtrodden.
That is what.
It is certainly
ED claiming that they are downtrodden, marginalized. They say marginalized by the court.
They are marginalized
By the court.
I really sympathize with them.
Every time they are.
That's all I can do. I really sympathize with them that they are marginalized by the courts.
Yes.
Anyway, but that's the parents' patria jurisdiction, Mullahs, that cannot be. And last of all, Mullahs, the first 2 propositions are right. Continuing right. There can be no invocation. And statutory authorities have no fundamental right as a proposition of law. This is page, Mullahs, para 150.
Yes.
It's elaborate discussion, Mullahs. Page 521 of that book, Mullahs. It's a sovereign power of guardianship over persons under disability. That's what it is. Sovereign power of guardianship. state has a legitimate interest under parents' patriarch powers in providing care to its citizens who are unable to take care of themselves. They take care of others, mullahs, but they can't say they can't take care of themselves. Then the court is also state within the meaning of Article 12. So you can, mullahs, in our opinion, in the case of an incompetent person who is unable to take a decision whether to withdraw life support or not, it is the court alone as parents' patriarch, which ultimately, that's mullahs, the decision, recent decision. So that's the parameters. You can't, mullahs, seek those concepts, mullahs, in a petition. And now, mullahs, after having said all that, I'm not, mullahs, purposely touching 66(2). You also may leave it, mullahs. These are my 5 propositions, right? Now kindly come to, mullahs, the prayer. And that's all, then I'm done.
Physics, page 46.
Yes. Now, mullahs, the prayer. Writ of mandamus directing CBI to investigate. What has that got to do with fundamental rights, mullah? The prayer is inconsistent with, mullahs, the averments made in the petition. They want the enforcement directorate wants the mandamus directing CBI to investigate. Where does CBI come into the picture? After all, there has to be a breach of a fundamental right. Pursuant to that breach, mullahs, there must be some investigation. That investigation, if not done, courts can be moved. But how is that available at this stage? We are not saying, mullahs, that we want a vindication of our fundamental rights. That's not what they are saying. They are saying you investigate. And that's why I read that judgment, mullahs, of the Customs Act. Merely because there's an allegation, you can't assume. So, mullahs, therefore, our submission at this point is, mullahs, facts we'll deal with later, that there is no right either of the enforcement directorate or the individual concerned, mullahs, to seek a prayer for investigation in the absence of a violation of a fundamental right, which is not possible in this case because all the offences alleged have happened in the past and there is no existing fundamental right. That's it. No, we are not concerned. I'm deeply obliged to you.
Yes. You can go.
I'm going. I will be very brief, my
You are for? You are appearing for?
I am appearing for Mamata Banerjee.
Yes.
No, I will be very brief because Mr. Dhawan and Mr. Sibal has made exhaustive argument. I will be very brief. Mirror, kindly see your Lordship's order, first on 15 January 2020.
Yes.
Can I give it? Okay. Paragraph.
Yes.
Number paragraph 16. Having heard learned counsel for both the parties, we are of the prima facie view that the present petitioners have raised a serious issue relating to investigation by the Directorate of Enforcement or other central agencies and its interference by state agencies. According to us, for adherence of rule of law in the country and to allow each organ to function independently, it is necessary to examine the issue so that offenders are not allowed to be protected under the shield of law enforcing agencies of a particular state. According to us, larger issues and questions have been raised and are involved in the present matters which, if allowed to remain undecided,
would further worsen the situation, and there will be a situation of lawlessness prevailing in one of the other states, considering that the different outfits are governing of defense. True, it is that any central agency has no power to interfere with the election work of any party. But at the same time, if central agencies are acting bona fidely to investigate any serious offense, the question arises as to whether, taking shield of its party activity, the agencies can be obstructed in carrying out their investigation power in a bona fide. Therefore, these are the largest questions happening. Now, they will ask whether these largest question touches with the constitutional law or statute. My humble submission would be before your lords. Questions which have been summarized by your lords. Issues are constitutional. And the argument which have been made, whether ED, etc., these issues are constitutional questions. If this is a constitutional question, then Article 145, because till now it has not yet been decided by this court that the ED can file a petition or not can file a petition.
Therefore, that issue has to be decided once for all.
One for all. Now, whether it's a constitutional question or statutory. If it is a statutory interpretation of the statute, then the already argument has been made that the Article 32 is not maintainable. I am not going there. If it is a constitutional question, what would be there? Well, then we have to come to Article 145 of the Constitution. Fairly similar, Article 145.
You are party in both the petitions.
Yes. But Article 145, my lord, kindly see, the Article 145.
That was argued by Mr. Diwan.
Correct. Therefore, if it is a question of constitutional question, it would be decided by a constitutional court. Now, just for your lordship's information is this, that what has happened, Miller?
No, but that would arise only when we hold that it is maintainable.
No, yes, but maintainable and even on maintainable.
Yes.
But whether
Suppose we dismiss the petition saying that it is not maintainable. Where is 145.3?
no, certainly. Now, just for your information,
Yes.
now your lordships will decide. Now, what has happened in Tamil Nadu, the ED has, on the basis of certain allegation, conducted one investigation, etc., etc. Now, there also ministers were involved. Now, the state government constituted an inquiry committee on that. State government constituted an inquiry committee, and the inquiry committee, ED came to the High Court, sought for stay of this inquiry committee and quashed of that notification. The learned single judge has passed an interim order, staying there. State of Tamil Nadu went to division bench, challenged that. And division bench has held there, the learned division bench has said, no, whether it's a juristic person or not juristic person, writ petition under 226 is a maintainable. Against that, state of Tamil Nadu has come up before this court. And in that matter, notice has been issued by this court.
That we know. That was subsequent to probably.
Yes. There was just
No, Mr. Banerjee, the whole difficulty is that now different political party will be governing central and the state. Suppose you come in power in the central tomorrow and the situation is reversed. In some other states, they are in power, you are in central government. And the same thing will happen if some of the chief minister of the other side does this.
the allegation is that
In 2030, 2031, if you come in power in central government and their chief minister does something like this, what will be your reaction?
reaction is one thing, And you know, legal
No,
question.
no, legal reaction.
Legal.
Reaction means not on the streets.
Legal.
On the streets, no,
No,
not
legal.
that reaction.
That's right. Legal questions, we have to go by the law.
That
Whatever-
is why, that
that's
is
right.
why we are considering law.
That's right. Your lordships will finally,
Yes.
finally your lordships are the final interpreter of the constitution. There's no, there's no doubt. And your lordship.
We will consider it only when we find it in the ultimate analysis that we can. Suppose we find that no, Article 32 cannot be invoked even for the officers.
Yes.
I'm in the first half also, I am telling you, reminding you that in addition to ED, in the other petition, the individual officers are also there.
Well, I'm
Suppose, maybe in the first petition, this Mr. Robin Hood is wearing two hats, one hat of ED and the other hat of his own individual personality. But in the second petition, ED is not there.
Well, I'm coming. Well,
And just address Mr. Singh, we will also come and join. Whether the officers of the ED cease to be citizen of India merely because at the point in time they are officers of the ED, do they cease to become citizen of India so that merely because they are officers of CD, they can be punged and done away with any wrong and they cannot approach under Article 32.
well,
Suppose there is no petition of ED and there is only one petition filed by the officers of the ED under Article 32. In what way you will deal with that petition independently? Just forget about it. Therefore, I asked whether you are a party in the second petition also.
yes.
Argue with that.
My lord. Yes, kindly.
Because you have number of judgments in your favor in as far as the ED petition is concerned and as far as the locus of ED as petitioner number 1 in the first petition. But just consider seriously the second petition also.
Very nice. Well,
Because that may trouble you, I am telling you.
No, it's all right.
In so far as the locus is concerned or the maintainability of 32 is concerned,
Lord, I always consider
unless we are open to you
that exactly.
in telling what is the thinking of the court or loud thinking of the court, in what way we are thinking, you will not be able to answer.
My lord, during my 45 years profession, I always consider one thing. A lawyer is very.
And never take that if the court is asking
No.
questions which are not comfortable.
No. My lord, just.
Or which may be slightly tilted towards the other side, that the court is hostile, court has assumed something and this and that.
My lord, allow me to finish my sentence, your lordships will understand. During 45 years of practice, my lord, I have always taken it. A lawyer who is appearing before the court is lucky because when he understands the judge's mind. To understand the judge's mind, it is a big job of a lawyer. Leave aside even words. A lawyer is a truly lawyer who assesses the eyes of the judges.
Correct? And you see, that is why in these days, our eyes are seen by the persons who have logged in also.
I leave aside. I am a very.
It is not that only you are looking at.
I am a very focused person.
You see, when persons who are not in the court, they are also looking at our eyes. Our job is more difficult.
I forget about who are taking who, and it's not that. I am a very focused person. I never see any other thing. I know my job, what I have to do. I have to watch who is looking, who is not looking, what is the action.
It is
That's
not
correct.
on you.
That is for your lordships to think about that. But so far the lawyer is concerned, even kindly do not excuse me, my lord. Kindly just I am taking your lordship.
No,
Even the
you take your own time.
even
You have not
body language of the judges. That's a very important point.
It is just reverse also. We see the body language of the lawyers also.
That's right.
And one judge, I am telling you, one judge used to say that I read the body language of the lawyer when he enters the courtroom. Not only when he is arguing. When he enters the courtroom, he looks at what is the frame of mind, what is his facial expression, gesture.
Exactly, that is in SP Gupta's case. When the collegium, regarding collegium was discussed, it was said earlier the practice was, whatever I have read it from there, Chief Justice is sending to another.
And you used to say demeanor of a lawyer.
Now they're sending it. Then the second judge is sending it, but he said no. When collectively they will see, they will understand the body language. Only they can come into taking a decision. That is the reason.
Correct.
That is the decision. And in virtual court, whenever I have done it, I thought that I am not correctly assessing the everything. It is only on physical appearance it can be assessed. Now, I am coming to the second. Now, kindly see, this is the notification. I just handing a word to your lordship. The notification, first notification is kindly that is 8th October 2009.
Notification issued by?
Issued by the Ministry of Finance. October 2009. In exercise of the powers conferred by the proviso to Article 309 of the Constitution and in supersession of the Direct Enforcement Group A Post Recruitment 1997, except as respect things done to or omitted to be done before such supersession, the President hereby makes the following rules to regulate the method of recruitment of Group A post in the Directorate of Enforcement, Ministry of Finance, Department of Revenue. So therefore, it is under the Ministry of Revenue. And kindly see schedule, Special Director of Enforcement. Number of post 3, classifications, General Central Service, scale of pay, that's not very important. But important is also then the promotion, etc. Then everything is governed. Everything is governed by this notification. That is therefore the officers are the officers of Ministry of Revenue, not the ED officers. May be posted under the ED Directorate, but they are the officers of the Ministry of Revenue, Finance. Now, kindly see my alert. The rules. Give us who and where is kindly take it.
No, therefore?
Therefore, what I am submitting, these are the officers of Ministry of Revenue. And if the Ministry of Revenue, if anybody is aggrieved is the Government of India Ministry of Revenue, not the any officers.
Same thing. Same argument which Mr. Diwan has raised.
Yes, exactly. The question which have been fallen from your lordships, there I give the answer, my lord. I am trying to make this submission. See, my lord, Enforcement Directorate or the Revenue Department is making a search.
Yes.
Now, someone has been buzzed into that. Who is affected? That officers are affected or Department of Revenue is affected. It is not his personal.
No, but the offence is registered against these officers, not against Government of India.
No, that is a different aspect.
No, that is one of the prayer.
One of the prayer, two
Yes.
different aspects. I am coming to two different aspects. One aspect is the questions which your lordships has framed, that is coming within this aspect. Paragraph 16, 17, what I have read to your lordships. Now the queries which have fallen from your lordships, that whether the they are having a, this is also same, Milord, 23rd March 2000,
Yes, same.
on same. They are the officers of the revenue. But they are not doing any work for personal.
Mhm.
They are doing the work, they are discharging official duties. Official duties, not any personal duty. Milord, I will be submitting to your lordship, Milord, while discharging the official duties, anything is wrong. Let's assume whatever has been made here. Then in that case, only the central government will come, not personally they will come.
Yes.
They are having their right, but that is non-official. Let's take the case of a sanction. When sanction is required and when sanction is not required. When a sanction is required, sanction is required only when that if the official are discharging their official duties. But sanction is not required when an officer is taking bribe during the discharge of duties. That question will be decided at the end of the trial whether he was discharging the duties official or not. Taking bribe is an official duty or non-official duty. What he wants to protect, what they want to protect is this things which have been seized and taken away, which they want to protect, which they wanted to protect. What is their grievances? Searches are not allowed to be done by them. If this is an official duty, then who will file the writ petition? Employer or an employee? Let's take it, Lord, the search has been conducted. Today, if your Lord says, it is whose property? Property of individual or property of the government? If it is a property of the government, how he can come? There is no infringement of any fundamental right of them. If any right has been curtailed, that is the right of the central government, whether they can file the Article 32 or 226. This is not subject matter of debate in this matter. So what is his point? It is a kindly just appreciate it will be already said, then again kindly at the cost of repetition. If this is allowed to be done, everyone will come under Article 32. Let's take it, Milord. Let's take it for assuming for the argument's sake. Argument's sake, they are enjoying a fundamental right. Let's assume for argument's sake. When individual is coming and approaching this court, does he enjoy higher right or higher privilege than any other citizen? Certainly answer would be no. Same putting they are there simply because ED officers, therefore they enjoy a higher right, higher responsibility, higher right than any other citizen of this country. That is not acceptable in the eye of law. It's my submission. Let's assume it has been done. Why this court will exercise the power under Article, they leave aside maintainable or not maintainable. I'm coming later on. Maintainable or not maintainable. Why this court will exercise? Every day, we can see that this court is saying, why you are here? High Court is near to your place, go there. But if this is allowed, then they should be treated as a privileged class of citizen in this country. Let's take it, a lawyer practicing in Supreme Court. There is a violation of fundamental rights.
Like there are privileged litigants.
Are they privileged?
Adjoining states.
No.
Punjab,
No.
Delhi,
Are they privileged?
they come to this court very often.
Let's take it. Even a lawyer doesn't enjoy any privilege under the Constitution. Even a journalist doesn't enjoy a privilege under the Constitution. Media does not enjoy any extra fundamental right than any other citizen. Therefore, whole aspect, today if it is any police, let's assume that state police officer is conducting a search against a customs officer. Unless Delhi Police Establishment Act, if the consent is not there, state will proceed with the investigation. And that time CBI comes and intervenes in the matter. And the police officer will come to High Court, the Supreme Court. It is ED. For ED, it is very easy. Delhi is the main office. Attorney General, Solicitor Generals are available. But there the High Court is available. There was law, your lordship will lay down the law. In the eye of law, no one is privileged. Therefore, Article 32 is not maintainable, whatever the allegations are there.
That is exactly going in our mind also.
Maybe shocking.
In the eye of law, nobody is above law.
Maybe shocking. Your lordship, no, this fact is very shocking. Therefore, let us depart from all principles of law which have been settled by the Supreme Court time and again. 9 judges bench, 5 judges bench, 3 judges bench. No, ED has come. That is not the law, and your lordship, I am sure that your lordship will not consider that part. While the court exists, every court has its equal power. No court is lower than, in a hierarchy, appeal, etc. That's a different thing. But can we underestimate a magistrate? Can we underestimate judicial officer? Can we underestimate High Court? Article 226. Effectively, if I have read it, that I've forgotten the judgment, that is, Supreme Court is not a higher forum, higher thing than the High Court, excepting under Article 136. We cannot undermine a judge of a High Court simply because ED has that. But to this extent, I will not repeat that part is my very much.
No, you are very focused. You continue.
I will just now, kindly see. May I just tell you, lordship, a very unique method has been adopted in this case. Very unique. Rather, I will use the expression to use the sentiment of the Supreme Court, emotion of the Supreme Court. ED cannot do, therefore officer will go. Officer will file. Officer will say violation of Article 32. Very unique. Must be, it is a brainchild of very eminent lawyers. I know, but I can't say. Yeah. I can't say. These are all brainchild of Mr. Mehta. I know that. So I am not saying. Yeah. See, he is saying, yes. There are so many instances fighting each other. There's no problem. Fighting each other in the court is a long years.
No, you have to fight.
That's right. I have to fight for our existence.
And the fight must go on.
Yes, I am fighting for our existence for last 10 years in this country itself. He knows.
I do not know.
I know very well. You are the important man of the country. There are very less important.
We can only smile, we cannot comment.
No, very important man. I don't know when I will be picked up. And it is Mr. Mehta only the persons who can advise. Anyway, that's not. Now, kindly see, now he has no, it's a unique method. To to dilute all the judgments which have been cited by Mr. Sibbal and Mr. Dhawan. ED cannot come, ED no come. All their judgments, I am not required to repeat this. The very unique submissions. And your lordships have put the question also that kindly, if the fundamental right of these ED officers is whether we cannot interfere. He knows where it has to be clicked. He knows that. That's the reason he has posed this question second. It is a new idea, new concept now has been started in this matter. Earlier nowhere there. Now, my lord, kindly see. Therefore, which ED cannot do directly here, can they do it indirectly by filing a writ petition to his officers? Let's assume that your lordship, there I am taking it, is that your lordship is
we are noting, we are
argument that there are no ED cannot file. Therefore, ED cannot file directly. Therefore, ED officer would go, my rights are violated. But although he is an officer of the Revenue Department.
Yes.
But it is a well settled which cannot be done directly, it cannot be done indirectly also.
Indirectly. Do.
Next point is, Lord, kindly see the just that petition. But I was reading the petition. Just one minute. That second petition I was reading. Yes. No, no, I can't. I'm only another thing. I can't repeat and I will not. But can you take the Nishant Kumar and others versus State of West Bengal petitions? Kindly take.
Yes.
Now, can you come to synopsis B? Kindly read 2. The petitioners are constant to approach this honorable court under the most extraordinary, unusual and unfortunate circumstances emerging from the, as pointed out in detail here under the petitioner investigating a multi-state money laundering. Petitioner is investigating a money laundering offence under which the proceeds of crime to the tune of 2,744.32 crores are derived from the illegal coal mining which was generated and laundered at the cost of the officers of petitioner number 1 proceed to search the residential premises. Now, all the petitioners are the officers of the petitioner number 1, this Nishant Kumar.
No, it is cut copy paste.
No, maybe. I'm just pressing whatever the copy paste, etc. What if maybe I have to press it?
No, but they have.
Now, at the time of drafting of the petition, Mr. Mehta has not taken care at all. That is very clear.
No, I think
They
we
take
don't
care-
draft.
No. Settle.
We don't draft.
No, settle.
But it's well drafted. We'll examine.
I know.
Answer that.
Anyway, no, I have no problem. Therefore, they are not the officers of the petitioner number 1. That goes. Petition is liable to be dismissed on that. You are the officers of the Department of Revenue working under the ED Directorate, not Nishant Kumar's officers. Then kindly see, come to page C. The officers of the petition court, the officers of the petitioners were threatened and were not permitted to conduct any further search in the premises. The very basis of the aberrament is gone, everything is gone. The searches were conducted at 2 places, so and so. Then Millard kindly come. This is the way they have drafted it, and the one marked it. Now, what is their identity? Let's check it, Millard. Even in the first petition, what is their identity? Identity is officers of the ED. No other identity. If no other identity is there, no violation of fundamental right. There is no other identity.
Yes.
Next one, my lord, directions for the CBI. Two judges. First one I will cite, my lord. 1993 supplementary 4 Supreme Court cases, 260.
Repeat what is the citation?
My lord, 1993 supplementary.
1993
Hello, sir.
supplementary
1993 supplementary 4 Supreme Court cases, page 260.
260.
Yes.
What is name?
My lord, Union of India and another versus W.N. Chada.
Oh, Vinchadda.
That is
Vinchadda.
that is the famous Bofors.
Before.
Kindly come to paragraph 92.
So you need a Bofors this time.
Huh?
You need a Bofors to bulldoze them.
My lord, this is I tell you also one thing, my lord. It's a pleasant experience to appear before Lordship's court and to argue the matter. Pleasant experience.
Yes, we also feel.
Pleasant experience.
Hearing you, it is such a.
And my lord, sometimes serious,
And
sometimes in lighter mood.
You should come
That
here
is-
regularly. Why
Yes.
only in this case?
It's a very pleasant experience, my lord.
Yes. Para?
Para, my lord, 92. Paragraph 92.
It is about that FIR. Right.
Accused
Right
has
of
the
hearing.
right to
Right of hearing to the accused.
Yes.
Yes.
More so, the accused has no right to have any say as regards the manner and method of investigation. How can they are the accused, my lord? How they can ask for CBI? How they
Yes.
can ask for CBI?
Yes.
And Mr. Raju is arguing every day on this point. Another one, Miller, another one judgment on this point. That is, Miller. 2011 5 Supreme Court cases, page 79. Narmada Rai versus State of Gujarat and others. Para 64. The above decisions and the principles stated herein have been referred to and followed by this court in
Mr. Banerjee, which paragraph you are reading?
paragraph 64.
64.
I don't have its copy here.
किसकी तरफ से किए गए?
अब जानते हैं तो किसका तरफ से होता
No, state also.
है? No, state. State is yours now.
No, state of West Bengal is not.
No, now state is
There, state of West Bengal is yours.
no. What has happened
Only
after
governance is there.
No. More debate will start after 15 March notification. First job they have done at 12 o'clock night. The chief secretary has been seated. Then director general. There's 79 officers. I was telling yesterday, I was arguing a matter also. The advocate general, don't worry, you may be removed in the evening. Everything has been taken away from the state.
No, whether advocate general can be removed by EC.
Anything, EC can do anything, my lord. EC is saying I have a superpower. And in West Bengal, there is an emergency now.
The difficulty is the parliament is ongoing and 4 eminent parliamentarians are here, my lord, defending that your lordship should not go into these serious issues. Therefore, he is forgotten that he is not in parliament. He is before the court.
No, I am just.
Whether EC is right, EC.
No. I am a bench. I've said I am very lucky.
Mr. SG, he knows what he is doing. Don't underestimate Mr. Banerjee.
I'm definitely not, my lord.
And you know what he is doing.
Anything other than, my lord, argument.
No, that argument I made yesterday. Tomorrow is a part of continuing. Tomorrow I will make that argument there in High Court website. I am arguing that matter. No, but I am very happy, my lord. I am telling you, Lord, I am so lucky that your lordships are so open and so amicable, my lord. I am so That is the reason I have get some courage to speak. Otherwise, I would not have said these things. Now, my lord, they kindly come to page paragraph 64. Mr. Mehta actually doesn't know me as parliamentarian, but you know, he is closely associated with him. He understands what I am.
Yes, I know. He's a nice gentleman. There is no doubt.
Nice gentleman, nice opposition.
Yes, sir. No, I'm not in ruling. You are not opposition at all.
Of course, opposition.
I'll not go into it, but I'm not in any political.
Opposition. No, they're in the parliament, not here. Here in the opposite party, I am appearing.
Correct, but I'm not in parliament, so you are not.
No, I am saying that Mr. Mehta doesn't know me as such. He only sees in the Malad in the court. One day you come there.
I will come.
Please. Next time. And you will be made a big minister.
No, I'll
Big
come as a visitor, not.
No, come there. Now, my kindness, paragraph 64. The above decisions and the principles stated herein above, referred to and followed by this court in Rubaddu by its sake, where also it was held that considering the fact that allegations have been leveled against high-level police officers despite the investigation made by the police authorities of the state of Gujarat ordered invested by CBI. Without entering into the allegation leveled by either of the parties, we are of the view that it would be prudent and advisable to transfer the investigation to an individual. It is tight law that accused persons do not have a say in the matter of appointment of an investigation agency. The accused person cannot choose as to which investigation agency must investigate the alleged offences committed by them. However, here in this case, they have not lodged any complaint. Leave aside anything. Well, what is the basic principles of the CBI? CPDR. I was argued from Calcutta High Court since my childhood. 17 years I have spent on that matter. What is the basic principles? First of all, there is a lacking of investigation. If the people doesn't have any confidence, it is not the question whether the court or you will approach the court and court will assume no, nothing can be done. With great respect to others. Public confidence, not the ED's confidence. The public confidence is lost and no one can assume that no, at this stage, nothing can be done. Bengal police is useless, they will not do anything. Number one. Number two, this is the prayer which have been read by Mr. Sibbal, that they transfer the investigation to the CBI. What is the foundation? First, there must be a complaint, there must be FIR. First of all, there is no complaint. Secondly, if the complaint has been made and no FIR has been lodged, then they are agreed and come to the court. There is no complaint has been made to the court. And thirdly, the FIR which has been initiated against them, there is another aspect where your lordships have stayed. Is there anything wrong has been done by the state police till now? Nothing is there. But I will, with great respect to your lordships, I will submit. This court will not preempt anything and pass the order according to their prayer. That is a matter to be seen later on. Now, next point, my lord. So for Article 14, 21, 22, elaborate submissions have been made, my lord. I am not required to. Only I will say, my lord, can there, let's take it. My lord, ED is a Ministry of Revenue. When the state versus state is there, Article 14, 21 is available. If it is not a juristic person, until your lordships hold it, and maintainable holding, Article 14, 21, not available. Your lordships will find the Part 3 of the Constitution, excepting Article 21, it is a case of a citizen of India. And Article 21 is concerned, person is there. It is a department, not a citizen. ED of, okay, I will not, so for this part, others will have argued, and my lord, I will be submitting, I will finish it by submitting that, my lord, and another one, just one, Delhi Police Special Establishment. Kind of similar, the Delhi Police Special Establishment. My lord, lordships have considered this only in a case if the state gives the consent, and other cases, Constitutional Court has the power. This is a well settled. I am not required to just answer.
Yes.
Now Constitutional Court when will give it? After looking into the FIR, whether it is within the ambit of the Supreme Court in Article 32 to direct to register FIR. And when it can be done when a complaint is there. Why you have not lost it? Which complaint is there before a lordship's court? What is the complaint? Article 32 petition is not a complaint. If complaint has been made and it has not been registered, and if a lordship see the allegations and thereafter come to a conclusion, yes, these are the allegations are there, Bengal Police, Calcutta Police has not done correctly or properly, only, my lord, I will be beseeching to your lordships to come into conclusion that yes, this is a case. But no complaint is there. My lord, it would be a very...
Yes.
But for the court, I am saying, if your lordships hold it, no, without complaint, one can come to the Supreme Court, find an Article 32, whatever their grievances. Well, your lordships can do so. But your lordships will be overburdening yourselves with that. To register FIR on a very first day, prayer is after incident coming to court and asking, making a prayer, that is, my lord, unprecedented. That is, my lord, unprecedented. There are cases where blood transfer of investigation is there. There are cases court has said, yes, there is a complaint. Why you have not acted? But here is not that. And on merit, I have, if your lordships ultimately hold it, no, it is maintainable, then we will come to your alternative remedy.
No, alternative remedy has to be argued now.
Argue. Okay.
Because that is one
Well,
facet of maintainability.
Well, let's see facts versus facts.
Like just Mr. Sibal has argued.
Well, if there is a disputed questions of fact, would your lordships consider?
Yes, disputed question of fact.
And read the affidavits of the everyone. I will not take your lordship's time. First question is facts versus facts. He is saying one fact, I am saying another fact. He is saying I have birds into their places, and Tuka, I am saying they have handed over it to me. When I have requested here, they have handed over to me. Therefore, fact versus fact. A disputed question of fact. If it is a disputed question of fact,
Yes.
but Article 32 is not ended. And that is the reason, my lord, last questions which you have, lordships have framed, whether the whether the ED will appropriate for the ED to take over the anything of the political party or not. That was also question was there. And that too, my lord, everything is done. That, see, my lord, 2 years have gone, 3 years have gone, nothing just before election. That is a sensitive, of course. My lord, I will make a last request. A request. My lord, when Justice Datu was here, became Chief Justice of India.
Achal Dattu.
Justice Datu,
Dattu.
long back. I was arguing a matter, in a Singur matters. Lordship knows that Singur matter has become a later on very important, that the transfer of Tata from,
Singur, that mining matter.
no, land acquisition.
Oh, your states.
NYAYA,
Oh.
Singur matter. And that too, my lord, just before 2011 election. Chief Justice Datu said, Mr. Bandyopadhyay will not hear this matter because election is forthcoming. The court do not want to be a party to any election. Because our saying in one thing,
We do not want to be a party to election, and we do not want to be a party to a crime also.
correct.
Let it be very clear.
No, crime also.
And there is no timing for a decision,
I
court
am
decision.
not saying there is no time.
Don't argue, Mr. Banerjee, and don't
Okay.
try to suggest this thing.
Okay. I will not argue.
Don't try to this. Never try to do this.
No, I will.
We know the timing of the court.
But I will not.
We know the timing
I
of
am
the
withdrawing
decision.
my request.
We know when the decision.
My lord, I am withdrawing my request. I can understand that. By
Yes,
this time that I can understand.
Yes.
I can withdraw.
Yes.
I can withdraw the request.
Yes.
That's much I can do, my lord. And your lordship will give a smile on that. Good smile.
You must have faith on the electorate.
The good smile. That we will fight it out. That is. Sir, these are my arguments.
Yes.
Deep respect. With your lordship, can I?
Where are you going out?
Now, I have
Be here.
at a courtroom number 1, there is one matter.
Okay.
Then I have to take the 6 o'clock flight. I am already in the election campaigning.
We know.
I'm only for this.
We know.
This time he's not campaigning for himself.
No.
He's campaigning for somebody special.
Mr. Bandyopadhyay is always special.
He's got a ticket.
No, I have, yes, that is correct. He is one of the candidates,
First
but
time.
I have to campaign for so many candidates. I cannot make discrimination on that. Develop justice.
Yes.
Whereas I was originally scheduled to argue last as the DGP.
Mhm.
So there is somebody else left for the state, I believe. So I had decided to open, if I had been arguing last, with that saying that after a
We propose to continue with this matter till 3:30. There is another that contempt matter. Contempt means that continuous mandamus. कौन सा number है वो?
I think it can be over. Mr. Dr. Singhvi is always very brief, concise and precise.
We have 15 minutes. So you continue.
Left-handed compliment to curtail me to 15 minutes.
No,
I
a
think that
genuine
I'm-
compliment.
I
This is
think
genuine
I call for that at this age. I am very grateful for your compliment.
Yeah, thank
You really expect me to finish in 15 minutes?
You can, therefore. You have nothing much to argue because rest of them have argued. That's all.
So that was
Yes,
what I was going to start with this. And he validates what I was going to say. And your lordship has been served a multi-course meal. When the dessert comes at the rare end, howsoever sweet it is, your lordship is looking at the exit door to leave.
But I love dessert.
But your lordship is looking by then to the exit door to leave. My learned friend wants to hasten that exit. So, well, it's first a couple of small short points. Firstly, Malits, when your lordship said about maintainability, I wanted to make one thing clear. Maintainability itself, and that's the way I understood Mr. Diwan, I may be wrong, itself is a significant, important question of law to be referred to a larger level. So it is not that your lordship will decide the reference, whether to refer or not, after deciding maintainability. The nuance is that your lordship may consider finding the issue of maintainability itself a significant, important issue of law requisite to be referred. That is one part which has been argued by Mr. Diwan.
Yes.
Now it is almost everything has been covered, so I will try to pick my steps and find things which are not touched upon. But it's one very important conceptual case is STC, of which Mr. Sibal read only page 35 and 36, one para each. It's an old vintage,
62.
9 judges.
Hmm.
9 judges. But the concept is very much more important for us. And I'm going to just consider that a little bit more. Read passage he did not read. And that is this, fellas. The concept of 3 or 4 things are inextricably intertwined conceptually with standing in a Article 32, Part 3. One concept is person, natural person. Call it human being or natural person. The other is a concept of citizen. You're not concerned with it here directly, but that's the second concept. And the third is the conceptual nature of persons to whom Part 3 was intended to apply.
Yes.
On all these 3 points, fellas, STC is extremely instructive. In fact, in 9 judges, fellas, Justice Sinha wrote one set of judgments. Justice Hidayatullah did a very exhaustive jurisprudential examination of the concept of person, entity, human being, citizen, and how everybody except this class is excluded from Part 3. And that is very important for us. And then there are dissents by 2 judges. So just come, I'll only consider some parts which are not read, but I'll come to the judgment and hand it over.
Yes.
Page. You will go.
It is here.
The first page of the judgment of this compilation. So, the matrix was identical to our case in terms of the context. See the first para of Justice Das for us. Das J in the beginning.
Which page?
Well, it's page 1, it starts.
No, one is Sinha. One is Sinha. Page 3 it starts. In your compilation.
In the compilation, the first page I'm told is.
Yes, Mr. Das.
S.K. Das.
Yes, S.K. Das.
J. In these writ petitions, the State Trading Corporation and KB Lal, etc., was at the time of filing Additional Secretary Ministry of Commerce, but is no longer holding, are the petitioners who seek relief against the state of Andhra in 2 of the petitions, state of Bihar in the 3rd petition, etc., by issuance of a writ of certiorari for quashing the orders of service. Then your lordship will see in the middle of the paragraph, next to next, 2 of these preliminary objections are whether the State Trading Corporation, a company registered, is a citizen in the meaning of Article 19 and can ask for enforcement of fundamental rights guaranteed to citizens. 2, whether State Trading Corporation is, notwithstanding the formality of incorporation under the Indian, in substance a department and organ of the government with the entirety contributed, can it claim to enforce fundamental rights under Part 3? These questions are very important to note. Then, brothers, comes the Chief Justice Sinha speaking in the opening part of the next page. He's speaking for a number of persons for us, 5 judges. And he formulates the questions. Again, I got that? Same questions for us. That's number 2 is the same question.
Yes.
Then see the last part, bottom of page 5. Sorry, 6. Last 2 lines of 5. It is on a consideration of the provisions of part 3 that the makers of the constitution deliberately, the design itself is very important. The design is different. The architecture of part 3 was intended differently. Advisedly made a clear distinction between fundamental rights available to any person and those guaranteed to all citizens. In other words, all citizens are persons, all persons are not citizens. Now, let us kindly note, in my case, the petitioner is neither a person nor a citizen. Please note that. He is neither a person nor a citizen. Except, Lordship, leave aside the Robin petitioner. I'll leave aside that for the time. Now, they deal with part 2, which is the Citizenship Act part. Come to page 9, but it has got to be said, they are discussing the whole of part 2, citizenship. I'm only doing some portion reading, but I'm not reading too much. It has got to be said that those observations, though they may appear to support the contention about the respondents, but not made directly with reference to the question now before us, namely whether a corporation could claim the status of a citizen. That question did not arise in the case because the company as such was not seeking any relief. Even if the company were interested in seeking relief, it could not do so without having the status of a citizen. Then see 2 paras below that. On an examination of the relevant provisions of the Constitution, the Citizenship Act aforesaid, we have, as already indicated, reached the conclusion that they do not contemplate a corporation as a citizen. But Mr. Setalvad, appearing among the petitioners, contended that part 2 is not relevant. Well, he argued, Setalvad argued this. Then, they give various things. And to cut a longer story short on this first judgment, please come to page 13. Middle. In view of what has been said, second sentence after that. Page 13.
Yes, it seems to us.
It seems to us that in view of what we have already said as to the distinction between citizenship and nationality, corporations may have nationality in accordance with the country of their incorporation. That does not necessarily confer citizenship on them. There is also no doubt in our mind that part 2 of the Constitution that deals with citizenship refers to natural persons only. These are 9 judges speaking in the 60s. This is further made absolutely clear by the Citizenship Act, which deals with citizenship after the Constitution came into force and confines it only to natural persons. Cannot accept the argument that there can be citizens of this country who are neither to be found within the 4 corners of part 2 or within the 4 corners of the Citizenship Act. We are of the opinion that these 2 provisions must be exhaustive citizens of this country. Part 2 dealing with citizens the date the Constitution came into force and the Citizenship Act dealing with citizens thereafter. We must therefore hold that these 2 provisions are completely exhaustive in citizens of this country, and these citizens can only be natural persons. Therefore, whereas they end this part, Justice Sinha ends for us, Chief Justice Sinha, by saying this first question must be answered in the negative. Well, Justice Hidayatullah, speaking for concurring judges, he is concurring fully. Kindly come to page 16. Top. This new legal personality emerges from the moment of incorporation, and from that date, the person subscribing to the memorandum of association as a person. Joining as members are regarded as a body corporate or a corporation aggregate, and the new person begins to function as an entity. But the members who form the incorporated company do not prove their status of their personality. Now, next sentence where I'm relying. If all of them are citizens of India, the company does not become a citizen of India. Any more than if all are married, the company would be a married person. the personality of the members has little to do with the persona of the incorporated company. This applies exactly and entirely to the department of a government. That persona that comes into being is not the aggregate of the persona either in law or in metaphor, and then it goes on to jurisprudential aspects, which are not reading. Then, on the next page, which is page 17, the last 10 lines, in my opinion, the state daily corporation cannot be said to be a citizen either by itself or by taking it as the aggregate.
Which page you are reading? Same page?
Next page, 17.
Next, 17.
Last, from the bottom, the last 10 lines or so,
Hmm.
12 lines.
In my opinion.
In my opinion, the state trading corporation cannot be said to be a citizen either by itself or by taking it as the aggregate of citizens. That nationality of a corporation is a different concept, not to be confused with citizenship of natural persons. That the word citizen in 19(1) F and G refers to a natural person. That the STC is really a department of the government behind the corporate veil, and that for all these reasons the two questions must be answered in parallel, etc. Then he gives very exhaustive reasons after this, jurisprudential. Now just note, look at this catch. You are either a citizen or a natural person. Nationality is something totally different. Well, I am registered in Luxembourg, I have a Luxembourg company, etc. The department of the government hypothesized cannot be either, and doesn't claim to be either. In which case, the total two categories of Part 3 articles, one category is non-14, non-21, applies to citizens. 14 and 21 apply to persons. In both cases, you are out. It's as simple as that. Now, the answer to that is not that by a process of reverse engineering, as these petitions are doing, purely by a process of reverse engineering, we are out. But because the action, the event is allegedly so serious, therefore you create jurisdiction when none exists. Look at the reasoning here. The reasoning is to make that event very serious. That it is serious or not, I'm not conceding at all. I'm not arguing the merits. Because a fact situation is painted as extremely serious, extremely purple, your lordship should A, make new law. Your lordship should do reverse engineering to fit in somewhere in Part 3. Your lordship should ignore 9 judges. This, incidentally, is the most followed judgment by 7 and 5, which I'll be citing, which have not been cited. He was accessible at Telco. There are other judgments. Now, I would say that in the hypothetical assumed scenario of a department as powerful, it was really very interesting to hear your Lordship's word marginalized and pressed. A department as powerful as ED, even assuming it was remediless, which it is not, I totally deny it. Even then, your Lordship would not create law under Part 3 because somebody tells the Lordship is remediless. Our founding fathers created an architecture and a scheme.
Yes.
Because Part 3 and this whole 32 is a creation of our founding fathers with an architecture and scheme in mind. Assuming without considering that it's remediless, your Lordship will not go to the extent of creating a remedy because remediless. Second answer, it is completely a self-serving argument, a figment of a very febrile imagination to suggest that it is remediless. Who says it is remediless? Well, let me take an analogy. In America, there are 2 sets of court and 2 sets of laws which apply on every citizen. There is a federal court and a state court. The citizen is subject to federal law and state law. In our case, we have federal law or central law and state law. But we don't have 2 sets of courts. We have a unified set of court applying both the laws. Because can anybody say that in any manner this party is remediless with the 226 staring him in the face? The argument remediless is self-created, self-serving, selfish, self-interested. So look at the reasoning. A, I know that reading Part 3 and 9 judges, I am neither citizen nor natural person. Now I have to get into it. So by reverse engineering, I say this. And if you pour deeply, I am not remediless. As a matter of fact, your Lordship knows well those judgments. In the debates also, Dr. Ambedkar also said that 226, otherwise its amplitude and plenitude is much larger. Any other purpose, my lord knows those cases, any other purpose. And it's a unified system of courts. 226 deals with everything which 32 Supreme Court deals with and more. The only difference is your lordship is 141, 142. That's a different matter. Otherwise, it has very much vaster power. So, in what manner are they remediless? In what manner should you do reverse engineering? And why should your lordship stretch the law for a situation which is allegedly fact-based, according to them, very serious? According to me, it's serious in the other way, that's a matter of fact. This is very important to keep in mind. Note one aside here, a slight interesting aside, and lordship will be very strict, but law is not a plaything just because an ED or just because a department comes here.
Nothing is a plaything.
It's a very important
We know.
the discipline of the law, just
Yes.
your lordship will see if a private person came.
Yes, yes.
Then we reverse the test.
Yes, exactly.
Just for a minute, assume that this side or the other side is a private person. What have they done, mothers? They say that we have filed a 226. It's an extraordinary case. They accept that the 226 is pending as we speak. As we speak. And they say that we have filed a 32, they say in writing, on identical facts. They filed a 32 on the same facts. Well, would your lordship give a reckoning like this to any private party? Your lordship will throw him out before he enters the doorroom, fellows. And your lordship should, rightly. On this, fellows, over adventurism of having identity in 226 is pending and 32 pending, my lord has this to say. Now, it's all very well to say, oh, we withdraw it. You can't take the court to be. Why you given Calcutta High Court, I asked. Pratibha Ramesh Patel, please don't do please. Have you given this one? Well, kindly take Pratibha Ramesh Patel. Forget the other one. Forget the other one for the time. You just take the judgment of Supreme Court called Pratibha Ramesh Patel. Don't give this without asking me.
Yes.
Now, in this, let us come to 8. Come to para 8. Virtually, the writ petition filed before this court is a true. I'm sorry.
Yeah. Yes.
And please apply the test that this is a private party coming to the doors of this court, not the ED. Virtually, the writ petition filed before this court is a true copy of the writ petition filed by the petitioner under 226 before the High Court, except for the disclosure of the pendency of the writ and some other minor changes. What is revealed from what we have narrated is certainly shocking. The petitioner having filed a writ before the High Court under Article 226, the writ petition having been admitted by the court, the High Court having granted an interim order which has worked itself out, and the petition is still pending before the High Court. Filing a writ petition under 32 of India is before this court is nothing but an abuse of process, if not misuse. Having invoked a constitutional remedy under High Court under 226, the petitioner cannot under law file another petition under 32 on identical set for identical reliefs, 1 lakh only. That is, what is sauce for the goose is sauce for the gander. If they are equal non-citizens and non-natural persons as other parties, they have no such special rights to abuse a process like this. And just see that other one-page order I have already given. This is what Mr. Raju's client, through Mr. Raju, specifically averred in the High Court order, the one-pager. Learned counsel for the petitioner seeks adjournment on the ground that the ED has filed the SLP before the Supreme Court with prayers which are almost identical to the present application. This is a remarkable case of a vice being proclaimed as a virtue with pride. I am proudly proclaiming a vice as virtue. A private party doesn't even throw it out. The High Court, Honorable Supreme Court is incised, etc. And that matter is still pending. What is the ED? Doesn't have any special 9th schedule immunity rules. They should not be allowed to do this. Now, to continue with STC. And you go to page 18. Page. Well, it's the last part of 18.
Yes.
Well, just above the quotation, you are supposed to be the people, just as Jariya said,
Yes,
we the
yes.
people. Above that. It is worth inquiring if there is any place at all other than 19 where not only a natural person or also an artificial person is made. The first words occur and then they give that list. Then Malas comes the next page, which is page 20.
Yes.
Middle. There remains only part 3 entitled Fundamental Rights. In Articles 15, 16, the word clearly means a natural person. The words religion, race, caste, sex, descent, place of birth, residence mark out a human being. In Article 18, which mentions titles, the natural person is again meant because titles are ordinarily conferred on individuals. The full analysis given by 9 pages 40 years, 60 years ago. In Article 29, where citizens residing in the territory having distinct language, scripture, or culture have been given a right to preserve the same, the word definitely refers to a natural person. In Article 22, entrance to education is guaranteed to citizens. Entrant can only be a natural person. Then, Malas, the above analysis show that in 34 places, the word citizen and citizenship refer to natural and not artificial persons. The question is whether in the 35th place the word is meant to include corporations aggregate. For this purpose, we must ascertain if there is anything special. Subclauses A to E of 19 contemplate natural persons. The claim is that the word citizen must bear a different meaning in respect of F to G because corporations acquire, hold and dispose of property and carry on trade or business. It is argued that if several citizens carry on business together as an incorporated company, they cannot lose, etc. They argue that the company should be included. The court does not ultimately agree. Then Malas come to page 22. Well, by the way, Malas, at the bottom of page 22, Justice Ayatullah starts with the entire concept of philosophical of citizenship from Rome and Greece. I'm not going to read it, but a very exhaustive discussion is there in the next 3 or 4 pages. The history is at 24, 22 is Rome and Greece, the history is at 24, and then Malas conclusions at 27.
24.
27. The previous was important as the research done in the exhaustive analysis of a survey.
I have attended.
I have attempted to establish that citizenship as viewed from country to country from one period to time to another was concerned with natural. He does the entire survey about the Indian and European history. In those 4 pages, I'm not saving time and not reading. Country to country and period to period was concerned with natural persons. The manner of acquisition of citizenship and nationality summed up in so and so. Then I'll skip that. Then your lordship will come to page 29. I may perhaps leave. And then there's a simple red only 36 and 37. Very the matter. I'm not repeating a single word. 36 middle and 36, 37 top he read. I hope your lordship is. It's very important because that's the conclusion.
Yes. 37.
Yeah, 36. No, I'm sorry, my apologies. No, I'm sorry. 35, I'm sorry, he did not read that. He read 35? Yeah, he read 35 and 36. I'm sorry, my apologies. 35, 5th line. It may be admitted that the STC, which is incorporated, is not a foreign country from there.
35. It
Yes.
may be admitted.
Yes. And then he read the whole thing down to the same analysis of the articles, which I'm not reading. 35 onwards till 36 middle. Finally, Malas, again a part he didn't read, 41. In fact, Malas, 39 bottom. This is 39 bottom, right? Yes. 39 bottom. 39 bottom now. There's a conclusion coming up.
But 35 bottom says, if you read 35 bottom,
Yes, certainly. The 7 freedoms guaranteed by 19.1 are for citizens. It was easy to say the word citizen included corporation.
no, before that, before 3 lines before Article 14, the following articles of the Constitution employ the word person, which applies equally to individuals and to corporations.
No, that's right. But they're going further to say that if you read it simpliciter, it would mean both. But it is intended to be limited to natural citizens only. That's why the next sentence will, my lord is right.
Yes.
This is how it is. They say if you read it simpliciter, it may include both. But then we are excluding corporation.
Yes.
That's the point. The next, what my lord is saying, Justice Mishra, very important. Just see the last two lines. It answers there.
Yes, yes, the seventh reason.
Guaranteed are for citizens. It is easy to say that the word citizen included corporations of Indian nationality for any purpose.
No, not about Article 19. You are reading last two lines, that is with reference to Article 19.
Yes.
But here, there is no application or protection of Article 19 they are seeking. They are seeking invocation of other articles for which the previous part.
Therefore, Maharaj, I said, they've given all 14, 20, 27, everything is given together.
You know, we have to be careful.
Yes.
You are 9 judges and 9 judges you are referring. I think they will also refer to these 9 judges.
So let
And
me-
this particular part
So let me be,
favors them.
so let me be clear. Maharaj.
Yes.
If this part is intended to suggest,
I am deliberately putting questions so that we are also clear. We are reading it correctly or not.
If this sentence, one line, is intended to suggest that a non-person, non-citizen. So there are two questions. It is clear that 14 and 21 don't require citizenship. Right? Bruce? Now the question is a department or a company either a human person or a citizen? Right? Bruce? It is equally clear it is neither. Now the question arises, if it is neither a natural person or a citizen, can the word person in 14, let us look at only 14 and 21, encompass? The whole judgment is based on this, that without being a natural person, you are not covered. Person word, that I read before this fellow, I read that again. Person covers natural persons only. That's what they are saying. Now, these two articles don't go beyond saying so. Let us assume you are not a citizen. Let's assume you are not a citizen. You will be still covered by 14 and 21. That's why we said in our constitution there are only two articles. Otherwise, most countries have only citizenship. Our country has gone further. We have non-citizens also included. But non-citizens or citizens, person must be natural.
Yes.
So therefore, my learned friends, I would welcome that they read it. I think it will be completely contrary to the
You have done with this STC?
last thing was 39 bottom. Last one. I am therefore of the opinion that the STC cannot be regarded as a citizen for 19. And then after that, they deal with lifting of the veil. Another argument was that you must lift the veil. That applies only to corporations. They reject that also. I will not read it, but it's just, that's the next part till the end. Now, a constitution bench in 64 followed it, which is called Telco, which your lordship has been cited.
No, if you are coming to some other judgment, then we'll take it on some other day.
Okay.
I wanted you to complete the STC, so.
Have you done STC?
Yes.
Can it be on first, subject to your lordship's convenience?
First and second.
Sir, Wednesday.
First and second, there is some difficulty. I'm not available.
Yes. From 7th, the constitution bench starts.
Oh.
The 7th, I am also in the constitution bench in the beginning.
7th is, it will last the whole week or what?
So earlier, it's part had so it better immediately.
No, that constitution bench will go.
I think so.
Will continue throughout the week or what?
It is notified
Up to 7th.
to 20th.
Okay.
So
that your lordship's memory is fresh, being a parted matter. That's the only.
No, we also want to
Yes, yes.
finish it early. So that 7th to 10th, it is not possible.
No, we can. I can do it a little in the week following the 7th. I mean, 7th.
Yes, yes.
We are on the same side. In fact, in Sabrimala, we are on the same side, and we are there to open. So therefore, after that,
I'd like to take a look at what's okay.
14th. 14th is Tuesday.
14.
Dr. Guruswamy is also arguing a lot on this matter.
So that's all on 14th given. Only date they are given.
Sir,
14th or 15th, which one?
15th.
15th will be better.
The 14th,
Sir,
14th is Tuesday. So that we may continue on 15th and 16th also.
there are two
and finish.
But then I had some problem in the first half on 14th personal problem.
That's all right,
If I
I'm
not-
still alive.
No, I'm saying, so far as I'm concerned, I may be allowed half an hour or so at post lunch on 14th.
Yes,
If you like-
Yes,
before
yes,
that, it will not be over.
See, in between,
That's
you can accommodate each other.
No, I'm making that.
We have to hear someone.
I'm sorry.
Either you start or Menika Gulkani,
we'll work it
and
out.
he will take.
Not, we will not cause any inconvenience to his personal problem. We'll-
Obliged, deeply obliged.
Yes.
Yes, Mr. Kapil Sibal concluded his arguments. Mr. Kapil Sibal and Mr. He writes Bandyopadhyay or Banerjee, what?
Well, this is Banerjee, but Bandyopadhyay is a correct Bengali.
Mr.
No,
Bandyopadhyay-
according to him, which is correct. That is.
It's true also. Bandyopadhyay is the original Bengali word. Anglicized.
That I know, but what he writes.
No,
That I know, but what he writes.
What he treats to be right, that's
No, he writes Bandyopadhyay.
Bandyopadhyay.
He referred to himself as Mr. Bandyopadhyay. He was referring to some Chief Justice and then he said.
Chattopadhyay and Bandyopadhyay are offended by the Anglicization. They are
Even
offended.
Mukhopadhyay is Mukherjee, my lord. Was
Mr. Kalyan Bandyopadhyay.
The
concluded their
Chattopadhyay
argument.
was Chatterjee, yes.
Full stop. Dr. Abhishek Singhvi is continuing with his argument. Full stop. Post the matter as part heard on 14th April. To be continued on 15th and 16th April also.
Obliged.
Interim order may continue.
The interim
Deeply
order.
obliged. Okay.
ये नोट तुम्हारे लगा लेना. कॉल कर